the Tuesday meeting of the House Judiciary Committee, and we have a number of items on our agenda today. I'm looking down the list here. I think, Mr. Estration, you've got a bill. I don't know who else is here yet. As far as others, oh, I'm sorry, Mr. Jaspers, I didn't see you there. Let's take Mr. Jaspers first. I think he's wanting to get his included, which is House Bill 76. Is that correct?
Yes, sir.
Well, we pull up House Bill 76, and Mr. Jasper, let me get you there. You want to have everybody join? You're welcome to invite them up.
I've got lots of backup, Mr. Chairman.
All right.
I think they want to hopefully
They
sit
don't come
back
sit
there.
with you?
No, maybe not.
Let's try and keep the door closed. The noise coming in is a little distracting sometimes. All right. We have before us House Bill 76. Mr. Jaspers.
Thank you, Mr. Chairman and committee. Thank you for your consideration of House Bill 76. This bill is further work of many. And when I was in subcommittee yesterday, I really wanted to brag on some folks, and I will, but this is further work of House Bill 1004 that was passed last session and signed by the governor. After that time, the not the governor, but the surveyors determined that 1004 did not meet their needs. And discussions began pretty quickly after that to create a corrective bill. We really started hard early in December, meeting together, and this culminated now in 76, which I submitted last week. Got to brag on Council Sean Marie Story for balancing the conversation between a lot of interested parties, with thoughts and reversions of this bill going back and forth for over 6 weeks. I was looking at the email string the other night, and there's over 200 of them. And the interesting part, just for discussion, is that they were in color. Each person had a different color, and so just a colorful discussion of each line of this bill, and it's worked out real good. GMA, ACCG, the surveyors, the Clerks Association, Mr. Holloman, outside counsel all worked very hard to get us where we are today, and very cooperative work. This creates a platform for which plats and condominium plans are recorded electronically in our clerk's offices across the state. That really starts on line 24 there at B, and it really says that plats will be submitted for filing with the clerk of court and submitted electronically. And the rest of the bill creates code that tells us how to do it, makes it very clear. Just like on line 34, it talks about format. Very clearly states formats are full size. Specifications are with the clerk's cooperative authority. On 42, talks about what the plat and the surveyors have to do, and rules and regulations by their association. Lines 46 through 80 specifically talk about what has to be on the plat. Very clear and very long discussed information. Something very different on line 86, you'll notice, as y'all are lawyers, there are boxes there.
Yep.
And those boxes will be on each plat. They describe the survey and the certificates needed. I have a description if you'd like for me to just tell you about each one of them.
Do they apply to different types of plat requirements? Such as
Yes, sir. Different types of
condominiums?
surveys for whether it be under a new bill, the old bill, redrawings, and even counties that don't have any kind of approval process. It covers all different factors of it. And I think, ACCG and GMA were very clear and worked on this. One thing I do want to point out in one of them, if you look at line 108, I think ACCG counsel was very good in putting this bold type in there, that just because a plat, had been recorded did not mean it was approved. And just, I think that's a good truth in lending, truth in advertising sort of thing. 129 through, these are cross-outs. That's where the boxes are created, and we took it out of the code. And it continues on through 146. On through there is all the certifications, the signatures, and that they can be brought in facsimile or electronically. An II and 153 electronic signatures, because this is moving toward a paperless submission process down the road, and this gets us there.
Okay.
If we look over on 179, and there's a lot of cross-outs prior to it, you know, it just really says when there's submissions, you know, that these subdivision regulations, no map would be filed without approval. And which of course is what we want, more cross-outs. And then we just get over to line 215. You know, we're under a current law of 1004 right now. And it's really just clearing up, you know, making sure that those that are filed between January 1st of this year and when this bill is signed by the governor, that they'll be okay according, if they're done according to code and filed electronically. And that's our bill. And you see in Section 3, to solve some of the problems that are out there, it will be effective upon signature of the governor.
Let me ask you a question, if I can, Mr. Jaspers. Going
Yes, sir.
back to page 2, and we talk about each plat shall be a full size. What is full size?
You know what, I asked that very same question, Mr. Chairman. And you know the answer from, and I'll let the knowing people talk, they said they know what it means. So would y'all like to, Mark?
Why don't you come up here and,
This is Mark Chastain with the Surveyors Association.
hey, Mr. Chastain.
Good afternoon, Mr. Chairman, members of the committee. I'm a land surveyor member of the Georgia Board of Registration, which is where I was this morning, and thank you for entertaining this bill and its
Yes.
efforts. Being that we're moving into a paperless era where everything is essentially computer generated, they would be prepared at full size where they would not be reduced to the point that they would not be legible.
What is full size?
Full size would be if the stated scale of the drawing, for example, is 1 inch equals 40 feet, the electronic image would be created at 1 inch equals 40 feet, so that if subsequent users of the public records printed it at full sized of the image, then they would get a full size reproduction on a piece of paper. I hope that makes sense. I may have done a clumsy
Somewhat,
job
but I
of
mean,
explaining
no
it.
plats. So what you're saying is the full size means whatever the measurement scale is on the plat itself.
Yes, sir, that's correct. And one reason to point that out is one of the problems that have been inherent at no fault of the clerks has been that due to restrictions on the size of their books and their county budgets, and I served 2 terms as a county commissioner, and I appreciate the clerks being mindful of their budgets, has been that often plats have to be reduced in order to fit into their book historically across all of Georgia. And when you do that, you start losing clarity. You start picking up, you know, fuzzy images, and it doesn't serve the public as well as being able to have a full-sized image.
I use the term sepia. That means the original document itself, doesn't it?
Yes, sir. A sepia is actually a term from the pre-digital era where the image was directly transposed onto another thick piece of drawing media.
And it used to be, to me at least, what little experience I have with this, but sepias usually came in, I'm saying, size about like this.
Yes, sir.
And is that still considered what might be a standard size for a plat, like a subdivision plat, or what?
Yes, sir. The sepias are no longer used, but what you're referring to is still common in that probably the most common sized used now by engineers and surveyors for most all their drawings is 24 inches by 36. And when you try to reduce that to a size that'll fit into a clerk's book, you lose a lot of that. What the language that you question about would do is preserve that electronic image at full sized. So even if they're only printing out a portion of it, say on legal size paper, they would be able to read that legal sized portion of that plat as if it was a photostatic copy of the original drawing.
Okay. Who had the bill last year, Mr. Jaspers?
You had to ask me that.
I'm just curious.
It was me.
Oh, you.
And
Well,
if-
I didn't
and if
mean
you
to
look-
put you on, so I just asked about the last year's bill, as I recall, was really just addressing the electronic filing question, was it not?
Yes, sir.
And making that a standard and uniform
Absolutely.
throughout the state. Okay.
And you'll see that on the first page at the very top, I'm the only one that signed it because I felt responsibility toward this bill
Okay.
to just me.
Stand alone.
Yes,
Mr.
sir.
Chairman, might I interject a brief comment? Through no fault of his own, this House Bill 1004, which he's referenced, had some inherent unintended consequences which were not really foresaw and have created not earth-shattering issues, but several issues to the point that our council, the AG's office, recommended corrective language in order to be able to create an environment where surveyors could properly certify surveys and be compliant. So I appreciate Representative Jaspers from taking this on. It speaks very well of him, and I appreciate y'all's attention to it.
Sure, thank you. Do we have any questions from members of the committee of the presenter? Yes, sir.
And I do, thank you, Mr. Chairman, and I do, Representative, remember you come in last year, and I'm trying to put my mind back to that, and it's harder and harder every year it goes by. So tell me succinctly, what is the problem and how are we fixing it?
Describe the problem, if you would. They're very well aware of the problems.
I'll do my very best to be succinct. Feel free to cut me off at any time. I'll take no offense to it.
No.
Essentially, in the protracted future, it's envisioned that all local authorities will have a platform for electronic submittal of plans and plats for building permits and subdivision plats and everything.
Okay.
To my knowledge, Gwinnett and Cherokee are the two counties in Georgia that have that, and I'd also kind of condition that as saying that's just in the unincorporated areas that are affected. The local cities within those counties do not have this massive infrastructure. I know that Cherokee County's system was over $100,000 and required a lot of training. It's a very good system, but most counties and cities can't bear that cost and are not ready to take that step. Being that the bill envisioned that era in the future, there's only one certification provided, which basically forces everyone into a box of doing a paperless remote approval process, which in my personal practice as a land surveyor I've witnessed mass confusion in 4 or 5 counties of how do we do this. I don't want you to certify it like House Bill 1004 says. I want to see the rubber stamps and the signatures like I always have. This is from the clerks and the planning officials, and the language in House Bill 1004 does not provide for that. So we're trying to kind of do a temporary force fit workaround, get the signatures, put the new certification on there, and just kind of wing it until this corrective act can be put in place. The other thing that was sort of unforeseen.
So on that point, if I may.
Yes, sir.
We're trying to make some kind of standardized electronic filing.
Yes, sir.
Okay.
That last year.
And the people who are going to have to receive this are going to be your cities and counties, right?
Yes, sir. The clerks of Superior Court.
Okay, so we're not talking about, you use the word planning. I'm thinking of planning and zoning. You're talking about.
Well,
you're talking about,
they work together.
Okay.
If I'm going to subdivide a piece of property
Right.
into 2 pieces or 100 pieces, I have to get the necessary approvals from the planning and zoning,
Right.
all their affiliated departments.
Right.
Then that approved plat is deposited with the clerk of Superior Court in their plat records. So it's a process that involves a lot of folks.
So you have to give it to the cities and the counties. We're talking about now how you will give it to electronically to the clerks of courts.
Yes, sir.
And they're on board with this. And is this putting anything on the cities and counties to have to do?
Sir, this will relieve it because basically
Relieve it.
what this does through and it's convoluted, probably more lengthy than you want to hear, but the 4 certification boxes have been evolved through a lengthy back and forth with all the stakeholders so that a rural county that wants to see rubber stamps and signatures can continue to do so as soon as this bill
You
is
got
enforced.
ACCG and GMA both shaking their heads back there, cats and dogs sleeping together, so it looks like we're good.
The other issue that I would be amiss if I didn't mention was that they accidentally brought over condominium drawings into the plat requirements, which there are certain condominium drawings defined elsewhere in Title 44 that are prepared by architects and engineers and depict floor plans and common areas and all the things that are pertinent to condominium. But House Bill 1004 actually drugged them over, and if the clerks enforce House Bill 1004 to the letter, they have to refuse condominium drawings unless the surveyor certifies them as a property survey,
Thank you,
which is
sir.
obviously.
Thank you.
Ms. Oliver? Did you have to? Okay, well, insurance,
Yes.
Sorry, Judge.
Yes,
Mike Brown?
yes.
Please.
Chairman, I'm going to ask you the same question I asked last year, and it has to do with line 25 that says they shall be submitted electronically. How do you know everybody in the state has the ability to submit electronically? And are we requiring those individuals to go out and buy something they otherwise would not have to have?
Actually, I don't mean to take the floor
ahead,
away,
go
but
ahead.
I can speak to that. I met with some clerks and surveyors just a couple of weeks ago.
I'm not worried about the clerks, I'm worried about surveyors.
No, the answer is twofold, and I'll try to rein it in. One is it's the equipment necessary to do it the easiest way. You might say is just a necessary part of doing business, but I understand undue hardship and forcing change when change may not need to be forced. I don't recall the bill number, but in 2012, the General Assembly passed and the governor signed a bill which required that all plats that are recorded be submitted on a CD. And so that requirement for electronic filing has been in place. What House Bill 1004 sought to do was, instead of physically presenting a disk with that file on it and 2 paper copies for public display, it transforms it to where it's simply uploaded onto a platform through the internet. So the electronic file that's filed has been in place for now 5 years almost. This is just transforming it to where it's submitted online and not handed to the clerk by hand. Now, in fairness, some clerks did obtain the necessary hardware to make their own electronic image, and so anybody that has any local courthouse that has an issue, they will already have gone through this process, and will already have that if they want to do that. But again, it's been in place since the House bill was passed in 2012, almost 5 years ago. I do know that House Bill 1004 did go into effect January the 1st of this year. It's been in effect almost a month, and there was some scrambling, there was some head scratching, and that's one of the reasons why we're here. Part of
That's
that.
reading from my question.
Yes, sir. We hope that this alleviates most of that issue and consternation, but it will not necessarily alleviate anybody of having to get equipment to produce the new format that's already been in effect. And I also point out to some colleagues of mine from the rural areas who say, I don't want to buy a scanner, I don't want to have to learn how to do this, which I'm sensitive to. It does not require the surveyor to do it. So just like when this House bill went into effect in 2012, several surveyors complained, I don't want to buy a scanner, and they quickly figured out that a lot of these places that have UPS store or a little reprographic print shop, they can scan it and make the image for the client. The law does not, nor does this House bill, specify that the surveyor has to be the one to prepare or present the electronic image. So the concise answer would be no, it doesn't really require any surveyors to go out and buy any new equipment. They may find it feasible, it might help them, but it's no more requirement than there has been for the last 5 years.
And also, Mr. Chairman, in 1004 last year, we made sure that, knowing what we know about internet access throughout the state, that along with the clerks, that there's an access terminal, that they're going to have availability to it, to bring the CD, to bring the flash drive, whatever they need, and can do it at the clerk's office.
That's a current provision that's not altered by this bill. It's the public portal.
Anything further, Mr. Conwell?
No, sir.
Any other questions from members of the committee? So who in Georgia has the ability to certify a plat? Surveyors, civil engineers, architects?
A plat by long-standing law since 1978 can only be certified by a land surveyor. There are these other drawings that are affiliated for condominiums, which may be certified by engineers and architects.
I thought civil engineers had the ability to also certify as to a plat.
No,
Don't?
sir. A lot of local ordinances say surveyor or engineer, but the law has been strictly surveyor since 1978.
Okay.
Before that, it was more common.
Okay. Nothing further? Mr. Jaspers, that covers it?
Yes, sir. I'd ask for y'all's favorable consideration on our
We'll
bill.
see if we're going to give it to you.
Okay.
If there's nothing further, no one else wishes to speak to House Bill 76. If not, we'll close all further public comments. The bill is now in the breast of the committee. Do we have a motion? Motion is to do pass. Do we have a second? And we have a second. Do we have discussion on the motion? Do we have any amendments to House Bill 76? There being none, the chair will call the main question, which is a motion do pass House Bill 76. All in favor signify by saying aye. Aye. Opposed, like sign. Thank you, Mr. Jaspers. Your bill is going forward to rules. Yes, sir. Now we'll take up Mr. Illustration's bill, which is House Bill 121, I believe, and 122. You want to do 121 first? Yes, sir. All right, please have a seat. Anyone to join you?
Mr. Jurcich, join me, please, Mr. Chairman.
Sure, absolutely. The knowledgeable one.
Yes, sir. Thank you, Mr. Chairman, members of the committee. I bring before you today House Bill 121 by committee substitute. This is LC 297308 ERS. Mr. Chairman, just to provide a brief overview, and I appreciate, Mr. Chairman, you giving us this hearing as well as the subcommittee, Fleming subcommittee, with a careful consideration given yesterday. Mr. Chairman, this bill is requested by the State Bar of Georgia. It is supported by the fiduciary section of the State Bar and a result of the Trust Code Revision Committee examining the Uniform Trust Code and seeking to consider or implement portions of the Uniform Code into Georgia law. Brief background, 2010 bill to revise the Trust Code was passed in Georgia. Some of the concepts that are included in this bill at that time were not as firm or common as they are today. And several of these concepts are in place in other states and also are in practice but are not codified. And as an attempt to briefly go over the content of the bill for the members, Section 1 of the bill covers virtual representation by another party of a concerning a trust, and leads into other aspects of the bill. Section 2 includes non-judicial settlement agreements, practices which are currently taking place where all the parties agree on a potential outcome that can be addressed without actually going to court. Section 3 of the bill involves the powers of the court and the settler, specifying these powers, which are important for other aspects of the bill. Section 4 has been described as decanting, or what I understand it to be is if you have an existing trust and a need arises, it might be necessary to create a second trust out of the first trust, and that process is provided for in Section 4 of the bill. Section 5 and 6 simply remove language that has been changed by the bill, and Section 7 increases the dollar threshold so as to avoid a circumstance where the substance of the trust is eaten away by fees to maintain the trust. So I would appreciate the committee's favorable consideration. Happy to answer any questions with the assistance of Mr. Jurcich, who is the chair of the fiduciary section of the State Bar.
Thank you. Mr. Jurcich, would you like to comment on the bill, since you've had a large part of the authorship of it?
I'm the former chair of the fiduciary law section and currently chair of the Trust Code Revision Committee, which, just to provide a little background, as Representative Illustration said, we did amend the Trust Code in 2010. The General Assembly amended the Trust Code. It was a comprehensive revision of the Trust Code, and at that time, there were some provisions in the Uniform Trust Code, which was relatively new at the time the committee started meeting to discuss the Trust Code, and other concepts that were floating around in other states and in trust law in general that the committee decided not to implement in the 2010 code and instead allow to percolate a little longer. So we waited some time after that and created a new committee in 2015 to start looking at some of those items, many of which are provisions of law that have been requested by section members or trustees, banks, and others that manage trusts in our states, as provisions that other states now do have that seem to have worked well and that Georgia ought to as well. And so our first batch of amendments, as it were, that are in this bill are related to the amendment of irrevocable trusts when the need arises for those kinds of changes. And what this does is both codifies some of the methods by which changes like that are made, adds to some of the existing methods for changing trusts, and then provides, as Representative Efstration said, a codification of an increasingly popular way of essentially modifying a trust, which is creating a new trust by using the power to distribute in the first trust, the so-called decanting, which is in section 4 of the bill. So we think there's widespread support in our section, certainly for these changes. We have put it out for comment. We got a number of comments from interested members that we did that we used to tweak the bill, and we asked for your favorable consideration of this as a desirable modernization of Georgia's trust code in the area of trust modification.
So you say section, you're talking about the State Bar section, standing committee on fiduciary law section?
That is correct. The fiduciary law section
And
is the
did
section.
it get favorable endorsement out of that section?
We got favorable endorsement from the section, its executive committee, and then it went through the process that the State Bar requires in order for a section to take a official position on a bill, and it ultimately gets approved by the Board of Governors.
And most important to me, what does Mary Rafford say about it?
Mary wrote me an email that she, since she couldn't be at yesterday's subcommittee meeting or today's committee meeting, and I can just quote a little bit from it. She says that she understands it may seem strange to members of the committee that were proposing changes to a trust code that was only enacted in 2010, but she said at that time we realized trust law was in a state of flux. There were many initiatives that were in their infancy at the time we were working on the code and chose not to address at the time, and rather thought it would be best to let some of those ideas play out in other states. She says, speaking for herself, not all the members of that former committee, she's confident that the proposals that this committee have been thoroughly studied and debated by competent trust lawyers, including her colleague, Professor Sam Donaldson, who is served as our reporter on the committee, and that the proposals will serve to enhance and refine the trust code that was enacted by the legislature back in 2010. So we're glad to have her support. In fact, through the process, we've been keeping her posted on it because she is, for us as well, the one of our guiding lights when we're amending these fiduciary laws in this state.
I'll say that this bill, as well as your next bill, is to us lawyers who call old lawyers, kind of turns upside down the basket of what we've always known as being fiduciary or trust law, the state law. Irrevocable does not mean irrevocable anymore. And there is no longer going to be a rule against perpetuities.
That's the next bill. That's
bill.
right.
So with that, I'll end my comments. Is anyone on the committee who wished to ask the presenters questions? I see none. It came out of Mr. Fleming's committee. Mr. Fleming, you want to have anything you want to say about the proposal?
No, sir.
You're clear with it?
Discussion yesterday.
All right. Do you have anyone else who wishes to speak to House Bill 121, Mr. Efstration?
No, sir.
If not, we will close off further public comment on House Bill 121. The chair will now entertain motions. Is there a motion to the bill? We have a motion to pass, and it is seconded. As a committee substitute, we had changes made yesterday, so we do have a committee substitute, excuse me. The motion is due pass. Is there discussion on the motion? If not, the chair will call the main question, which is motion due pass House Bill 121 as a committee substitute. All in favor signify by saying aye. Opposed, like sign. Motion carries. And while you remain seated, we'll let you, Mr. Efstration, give a response to House Bill 122. Present that for us.
Thank you, Mr. Chairman. I present House Bill 122 as introduced, LC 297231. As was mentioned and discussed as well in subcommittee yesterday, the rule against perpetuities is something that attorneys remember very well from law school, or maybe not so well if you don't commonly practice in the area. But it's this bill too has been recommended by the State Bar of Georgia and supported by the fiduciary section. I believe came out of the same trust committee.
It came out of our legislation committee.
Thank
Yeah.
you. The
In fact, we had
Sure.
this last year, did we not?
I believe it was several years ago,
Several
Mr. Chairman.
years? Okay.
But the members might have in your materials and I see one that's sitting out, a map, and I think the visual aspect is helpful in this area. The rule against perpetuities, the year number has been increased in the surrounding states over the past few years with the accompanying dates provided. It's my understanding in some states that 1,000 years is utilized. 360 is chosen in House Bill 122 because it's consistent with several surrounding states, would put us on the bar with what wear seeing in other states, and would prevent the necessity, as was discussed in subcommittee, the necessity of potentially of Georgians having to go to another state to seek the creation of a trust. Mr. Chairman, if it's acceptable, I'd ask Mr. Jersich to supplement anything else that he thinks it's important for the committee to know.
Yes, sir.
Well, as Representative Willard, as you said, with trust law turning upside down and irrevocable, not necessarily meaning irrevocable, and now perpetual is now in fashion as well. This move that is now of the vast majority, actually now, of states have done this to repeal the old rule against perpetuities comes out of the constant battle that you see between tax law and property law that you even saw back in medieval England that resulted in the rise of some of these ancient rules. The old rule was that a trust could not last forever, that it could last only for the lives of everyone who were in being at the time it was created, plus another 21 years. And that served to limit the time property could be in trust. And for purposes of our federal estate and gift and generation skipping tax, it means that after a certain time, a trust has to end and those assets are back in the hands of persons and subject to that estate and generation skipping tax. But when Congress decided to allow you to have a trust and not have it subject to any generation skipping tax so long as it stayed in trust, there became a movement to allow trust to remain for much longer. Some states just repealed the rule entirely to allow a trust to last forever. Some states decided to just change the old statutory rule that said lives in being plus 21 years or 90 years, and just change that 90 year to some larger amount. And as Representative Estration said, some states did 1,000, one state did 500, one state did 360, and that was Florida. And it's never been quite clear exactly why they chose 360, other than that it was a multiple of 90. But they did it first, and many surrounding states did it as well. Alabama and Mississippi and Tennessee adopted that same 360 years as really just a proxy. There are some technical tax and generation skipping rules why it was thought better to have an actual fixed year instead of just repealing the rule entirely, and so that's why we've decided to join them and do it that way as well.
Thank you. Do we have any questions of the presenters? Members of the committee. Mr. Kelly?
I already have a question, Mr. Chairman. I just want it noted on the record that ever since this first subcommittee, I've had nightmares about my real property class.
I understand. Appreciate that. Further comments or questions? If not, is there anyone else who would like to speak to the bill? House Bill 122. If not, we'll close all further public comments. The bill is now in the breast of the committee. Chair will entertain motions. Do we have a motion?
Do pass.
Motion is due pass. And do we have a second? And it's been seconded. Any discussion on the motion? Any amendments? If there are none, the chair will call the main question, which is a due pass House Bill 122, as presented, by the way. No substitute. All in favor signify by saying aye. Opposed, like sign. Motion carries. Thank you, sir.
Thank you, Mr. Chairman.
Appreciate you coming down and being with us today, too.
Thank you.
Let me also take a moment, personal privilege. We have two Superior Court judges I know. Judge Arch McGarity from Henry County and Judge Boyette from Calasaga, that's it. Yes, sir. We're pleased to have both of you with us. Do we have any other Judiciary members in our audience today? Well, thank you for coming and being with us. Y'all working as a pair this week? Okay. Y'all been running together for a while. Okay. Let me bring up House Bill 1 at this time, which is the bill by Representative Spencer. If you would come around, please, sir. This will be we're working off LC 363182S as a committee substitute bill. Ms. Spencer, do you have anyone you want to bring up with you? You certainly may do so.
Yes, sir, I do.
Have a seat and introduce your guest to us, if you would.
This is Mr. Joe Hardy. He's with the Space and Aviation Hardy Law Firm. So he is a little bit of an expertise in some of the federal law.
All right.
So if we ever get into the weeds on the federal law, he will be able to assist us on that.
Weeds.
Okay. So let me know when you're ready, Mr.
We're
Chairman.
ready to go to list for the committee's edification. This was the bill that we had last year, I believe also. What was the number of the bill last year, if you recall?
It was House Bill 734 last year.
734, and it came out of this committee, went through rules, went to the floor, passed, went to the Senate, and then from there was a study committee set
Yes,
up,
sir.
whether or not, was it a joint committee or just by the Senate?
We had the House Science and Technology Committee created a subcommittee, which I chaired, and we held 2 hearings over the summer. And then the Senate held 2 hearings over the summer and fall. And so there's been several hours of study on this issue.
Okay. And so as a result of those committees, as well as the bill last year, you've had prepared House Bill 1.
Correct.
All right. Go ahead and present for us.
So just to extend the remarks on that point, Mr. Chairman, we've had about 4 hours total with 4 hours each for the study committee on hearing that. If you count the hours that last year we spent on studying this issue and the subcommittee that we had last week, we're well over 14 hours on studying this issue. So this bill has been beat to death, if you would. But we have uncovered a lot of things on this bill. And even during our studies, we actually pulled up a 1998 study committee that the Senate created on commercial space and would it be feasible to do economic development with that industry. And so they recommended us moving forward on that as well. And I have that report if you need to see that. But that was a 1998 Senate study committee. Also, I gave the subcommittee last week a report that the Senate recommended in their number 1 recommendation to send a clear signal to the commercial space industry that we should pass a bill like the Georgia Space Flight Act. So with that, I can walk the rest of the committee members through the current bill. And we're working off of LC 363182S. And right there at line 9 is what we call the Georgia Space Flight Act. And I think this title sends a very clear signal to the industry and is congruent with the committee's report from the Senate. And so I would urge the committee to keep that name intact. Also, I would like to bring your attention to line 17. That's where we define crew member, and the various definitions are there. And I'll take your attention to line 32 through 35. That's a slight change from House Bill 734. Okay.
We're dealing off LC number 363182.
82S.
That's all right. That's all right.
Okay. Oh, did I? I'm sorry. 363182S. Yes. All right. All right. So at lines 32 through 35, that's a slight change from House Bill 734. We decided to sort of define reentry vehicle because we're starting to see these rockets bring back their initial stage back to land to be reused, which reduces these costs. So the technology is improving. Also, bringing your attention to line 47. that defines spaceflight activities. This is the scope of what spaceflight activities are. You can read through that again at line 59 rather. Again, we define spaceflight entity and what that means. Bring your attention to line 64 and 65 of the bill. That is key to this bill being extremely competitive. As I've stated before, we want to be competitive with our neighbor, especially Florida. Obviously, Florida has been in this business a long time. For us to be as competitive with the state of Florida, we need to keep this line intact. I know at the other subcommittee hearing I know there was an effort to try to change that, but to keep us competitive, we need to try to keep this intact. Also at line 73, it defines spaceflight participant. This involves individuals not only carried aboard, but those who have also taken the steps towards being carried aboard, should they decide to sign the waiver. Also, in lines 80, we are defining spaceflight participant injury. And these injuries must relate to some spaceflight activity, and the Georgia Spaceflight Act limits injury to those from inherent risk associated with spaceflight. And if you would bring your attentions to lines 116 and 128 of the warning and agreement, that's what we're talking about, and that's what that applies to. Also, looking at lines 97 and 98, if you want, sort of bring your attention back to 95, starting with that paragraph. We are not keeping these folks immune from gross negligence. That would be against state policy, so that state policy stays intact. So just wanted to make the committee aware of that. And at line 100, the uninvolved public continues to maintain their rights to file claims, and we made that clear at line 100. And in lines 107 through 109, that is simply just restating the applicability of other limitations of liability under the assumption of risk, which a lot of you attorneys are absolutely familiar with. Moving down to the warning and agreement at 114, there's the text of the language there. This is modeled after the Georgia agritourism and the equine waiver, very, very similar to that. So that's sort of taking language from there. And back down in lines 150 through 154, that's a slight change from last year's bill. That language just simply, in my opinion, sort of buttresses the language that is in the warning and waiver up there at the top. So I don't really believe that changes any substance to the bill. And going back up to line 148 and 149, that's the think it over period for the participant. And that essentially concludes the bill, and this sets the minimum standard for us to be competitive to bring the space industry to Georgia.
All right. And will you guess you'll have any comments?
No, I don't, sir. Thank you.
Who's this? Ms. Evans.
Thank you, Mr. Chairman. Representative Spencer, on lines 64 and 65, we did discuss that a little bit in the subcommittee meeting, and I understand the desire to want to keep us competitive with Florida. So I had looked back. I had a concern about that language, particularly the word services at line 64, because of a fear that we're going to somehow provide immunity to food services and things like that. So I got curious, and I looked back at Florida's law. And Florida's law does have this language about manufacturer, supplier of components, services, spacecrafts, but it limits it specifically to those things that have been reviewed by the U.S. Federal Aviation Administration as part of issuing the license that's referred to in subparagraph A. Mm-hmm. So I wanted to see if you would be amenable to that descriptor on the manufacturer supplier, since it matches up exactly with the Florida law.
We need to be as competitive or more competitive than Florida. So that's sort of my position is if we can take business from Florida, I'm willing to do that. So if that language does this, I'd say we stay more competitive than Florida.
But do you understand that Florida may have included that language, that limiting language, like Federal Aviation Administration, just like is in our subparagraph A, because that's the rigor that we want, that we go through, that we make our space flight vehicles and parts go through, and we're essentially making if we leave it the way you've drafted it in subparagraph A, we're having that extra step of the FAA for parts for the for the person that conducts the space flight activities, but not for the parts of the actual plane. So why would we do it for one if not the other? We obviously have understood it's important to put it in A. Why wouldn't we also put it in B?
What I do know about the licensing process and the oversight of engineers, aerospace engineers, if this body remembers, 2 years ago I passed a bill that would exempt aerospace engineers from licensing because the Department of Defense and the FAA already have oversight over their competencies and their training. So they're already under FAA oversight. So whatever parts and components are actually created, this has to go through FAA oversight. And so that I understand that part of the process. So I'm not sure if that recommendation would be needed, because it may just be redundant.
If it's redundant, then it doesn't hurt, right?
That you would know of what you speak, I suppose.
Thanks.
Anything further?
No, thank you, Mr.
Mr. Fleming?
Wait for right now, Mr. Chairman.
Okay. Ms. Oliver?
You and I were the two people on the subcommittee of the House, and so you and I have spent about at least 14 hours together on this. And I've learned a great deal about this. This bill does not address the permitting process, the environmental study, the consultant fees, none of that that's going on right now. Is that correct?
This bill has nothing to do with the FAA regulations or
All of
environmental
the,
impact.
and Camden County is participating in a permitting process.
Correct.
And a lot of our, just for the sake of committee, one of the things that's confused me about this is that the density of the federal review process raises substantial questions on both sides about whether or not Camden County would ever be eligible for this process. That's been a lot of our discussion, hasn't it?
Some of it, yes, it's been some of that discussion.
For instance, your site location is a chemically damaged area of former industrial park.
It is an industrial park.
And whether or not that can be used, whether that has to be cleaned before a permit is granted, is a question I was never able to get answered. Do you have an opinion whether that has to be cleaned before the permit is issued?
I don't know what the recommendation is going to be. I can only surmise and speculate at this point because none of us know. We are waiting on the FAA to render us an opinion. I got an email yesterday from the FAA that they're about to give the EIS draft in about 2 months. So in about 2 months from now, we will know the answer to that question.
The environmental impact statement has not been issued yet. That's what you're talking about.
Yes, so the draft statement will be issued, and we'll probably know more to the answer to that question as soon as we get a draft EIS report.
And the study committee, we clarified you are not, you being entities to build a state spaceport, are not going to be asking for state money in any way. Is that correct?
That is not their intention. At this point, that is
their
not
intention.
That is not their they have not told me or those that are pushing for the license that they're looking for a subsidy or a handout from the government.
So our competitors are really private spaceport, not state-sponsored spaceport. Is that correct?
Commercial entities, yes.
Privately
Private.
built.
Yes.
And there exist how many private spaceports have been built in this country?
I'll have to go back and look at that. You may. Do you know?
I can't remember. I don't know if I know them all off the top of my head, but there are some actually that are started off as government sites, like in Florida, that are now being operated privately. And I think the first purpose-built commercial spaceport private was in New Mexico. That might have been the only one so far. I think the others started off as either an airport or spaceport and then became private.
And there's substantial $15 million a year, $20 million state support for the private launch site in New Mexico. Is that correct?
There is substantial support. I don't know the numbers, but that's true. But there's, I think, I don't know the numbers, but there's also substantial investment from Virgin Galactic in New Mexico.
Many of these, as he was saying, many of these spaceports that exist now were government. And because the commercial space industry is starting to really grow, they are pushing and itching for a site that does not interfere with their launch capabilities. The problem is they have to compete with the federal government, to essentially put their payloads up into space. So if the feds want to put something up in space, whether that be a national security issue, a military issue, that's going to take precedent. And so the commercial industry is looking for a site that is strictly devoted to commercial space activity. And the site in Camden County is the premier site on the east coast of the United States. And that's why they're looking for
May I have
this.
one follow-up question?
Sure.
A lot of the hearing testimony did relate to those issues. Really, is it realistic that a private entity is going to build in Camden County, given the legal questions? And there's only one private entity, solely private entity, that started to be built on the Texas-Mexican border by Mr.
Musk.
Mr.
yes.
Musk.
Mhm.
So there are really only two private entities involved now. And right now, they lease space and launch site from Canaveral, really. That's how it works today.
Yeah, and many, like I said, many of the commercial folks use the federal ranges to get their payloads up into space.
The real question that was never answered for me is whether or not a permit could ever be permitted to go over a populated area of private residence.
Well, I think that'll all be given in the report in about 2 months. But the regulation that governs that is in the Federal Registry 43, and I think were at these hearings and you heard that. And so those calculations, by all experts that I have talked to and that are familiar with this process, they are pretty confident that this site will be licensed based on those calculations.
And there's a dispute about that.
Well, if you talk to the experts that are familiar with the federal regulation, they state that at 12 launches per year, which is what our permit is going for, even a single expected casualty in 500 years would fail the FAA's risk test and a license would not be issued. And so they did state in our committee hearings that in over 300 licensed launches by the FAA, there's never been a casualty of the uninvolved public. So I don't think the FAA is going to risk that record of perfect record for Camden County, and they'll let us know for sure, but we'll know that in about 2 months. But talking to industry experts that are very familiar with these regulations, it looks good for Camden County.
Y'all are gambling $5 million you've appropriated to.
There is a $5 million bond that the county has.
It's all Camden County money.
Yes.
Okay.
Yeah.
Thank you, ma'am. Mr. Bruce.
You may have answered this and I missed it. Are there any other places operating now doing what you want to do with this site? Is there anywhere?
Commercial spaceflight?
Yeah. What you want to do with this site? Is anybody else doing it at this point?
Well, every site has their own unique capabilities, but if you're looking at a site similar, not exactly the same, to Camden County is Virginia and Kennedy. I mean, we're looking at over the ocean. There's a natural habitat that surrounds it. There's a wildlife refuge at both sites at Wallops Island, Virginia, and at Kennedy, and they coexist. So, and these are things that are being taken into consideration.
And all of the flights that are leaving out of those locations are just carrying payloads. They're not carrying people. Is that
well,
correct?
down at Kennedy, they carry passengers.
Other than
yeah,
the
down
government.
at Kennedy and at Wallops, they will carry passengers.
But that's government stuff there.
Well, there's commercial and government launches. Yes.
People that are not
Kennedy,
military.
At Kennedy, there are private. Yes, the SpaceX, I believe, is looking to create the first capsule that will dock with the International Space Station. I believe so. You may correct me on that if I'm wrong. But right now, most of our manned flights, right now at the present time, but they have been done human flights, are done by the Russians. And so that's one of the reasons I'm sort of motivated to get a bill like this through, so we can the United States can enhance its capability. We're not relying on the Russians to put those folks up into space. And so if we can be competitive in that area, I say why not?
And what are they doing while they're out there? Do you know?
There's all kinds of missions, research.
Okay.
I can look that up for you.
I was just wondering.
That goes on and on.
Yeah,
I would say, remember Tang. That
Yeah.
They created Tang up in space.
Okay.
Yes, sir, Mr. Fleming.
Thank you, Mr. Chairman. Representative Spencer, let's talk about a second what Representative Evans was asking you about, and that is she wants to add some language on line 64. I didn't know if your council had any comments on how that would affect the bill or not.
Well,
Do you want
I
to
agree that Florida does say that, and I see what you're saying, and yeah, and I, like Representative Spencer says, it would water down this bill a bit because right now it is not so limited. It would be an added limitation that would be consistent with Florida and Texas.
So is that good or bad?
More of a policy,
That's
but
that's
if
a
I'm
policy call.
if the basis for this is to convince private spaceflight entities to come into Georgia, they, I think, would want the broader scope, which would be this, which would be as the bill is written now.
Okay, thank you.
Thank you. There are no further questions of the presenters. We appreciate you, and we have some others who have signed up for opportunity to speak to the committee. Mr. John Watson with, I believe, Mr. Dick Parker, and Kevin Lang. Yes, sir. Y'all want to come together or separately? Be together, all right? So the quarter's a little bit tight here. Appreciate it. We can't move the pole, though.
I'll step back.
All right, Mr. Watson, why don't you introduce yourself and the individuals with you?
Yes, sir, Mr. Chairman. For the record, my name is John Watson, representing Coastal Communities, LLC. Those are the homeowners that have property and live on Cumberland and Little Cumberland Island. With me today, representing that group of homeowners, is Mr. Kevin Lang and Mr. Dick Parker. Certainly appreciate at the beginning the committee's many hours of consideration of this topic. With that said, it would be our urging for continued conversation on this subject matter. As has been noted in committee today, there are a number of unresolved questions about safety, about the environment, about the viability of this project, and principally, Mr. Chairman, I know that we'd like to discuss some of the private property rights that this committee did not, in my estimation, have a full vetting of in its hearing last year. And so with that, I'll turn testimony over to Mr. Parker.
Thank you.
Yes, sir.
Mr. Chairman, my name is Dick Parker. Thank you for your attention to this issue today. In 2000,
Use that mic if you can. Might get a
Excuse me,
little
am I-
closer. There you go.
Yes, sir.
There are millions of people watching on television.
Yes, sir. In 2006, this committee responded to the U.S. Supreme Court's Kelo decision with by recommending passage of the Landowners' Bill of Rights and Private Property Protection Act. It was overwhelmingly approved by Georgia voters as a constitutional amendment to prevent government from taking private property for economic development. I mention this because my wife and I are among a group of private owners on the Georgia coast, private property owners who are facing the very threat that this committee envisioned in 2006. Spaceport Camden plans to build a $100 million spaceport so that private companies can launch rockets over our homes. I've distributed a map like the one that Representative Spencer shared with the Kelly subcommittee last week. He shows the trajectory of a proposed launch as well as the hazard and closure zones that such a launch would require. We've added some blue dots to indicate private homes, and we've added a white line that you can see that shows the location of Little Cumberland Island, which is private property. As you can see, the statement on last week's map that Little Cumberland was not included in the closure zone was incorrect. There are 21 private homes on Little Cumberland Island and 17 on Cumberland Island that are included in the closure or hazard zones. Regarding launch safety, Representative Spencer made reference to this in the Federal Register, which I have handed out to you on the, if you look on the second page there, at the bottom right, paragraph B, 417.13, Land Hazard Areas Analysis. The very last line of that paragraph says, a launch operator may initiate flight only if no member of the public is present within the land hazard area. That would be the yellow area that Mr. Spencer has delineated on his map. So there's no ambiguity here. Every person whose private property lies within the zone will have to leave and stay away on the day of every launch, whether it's Thanksgiving Day or whether it's 4 in the morning. Government requiring people to leave their land so private companies can conduct business amounts to an unconstitutional taking. Representative Spencer has said that House Bill 1 is about sending a message to the space industry that Spaceport Camden is competing in the space business. This committee sent a different message in 2006, which Governor Perdue summed up this way: it is wrong for your house, your land, and your property to be held in jeopardy at the sway of a powerful government. We ask you not to send a message to private companies that indicates that Georgia is willing to back away from that clear statement. Thank you.
Thank you. Yes, sir.
Chairman Wheeler, thank you for letting us speak today. And the reason the issue that Dick just mentioned is important is because in order to clear this land, this hazard area that you're looking at on this map, Camden County has to have some legal mechanism to do it. Either that or they have to reach an agreement with 101 property owners, which are the number of property owners on Little Cumberland Island and Cumberland Island. We've consistently asked this question with the leadership in Camden County. Unless we're missing something, there's a key element of this project's viability that is being overlooked, which is, what is the legal mechanism to clear this hazard area? Because I can assure you, as you guys know, it's impossible to get 101 people to agree on anything, much less to take a payment from SpaceX or Blue Origin to not visit their beach property or to leave the island in the case of people that are on the island full time. That's a key issue with respect to this project. And frankly, it's a key issue that we're getting no response from Camden County, the leadership, on. And this project continues going down the tracks. Tax dollars continue to get spent. And it's at some point, it is an issue that will be, it's a dead end for this project. And for that reason, we continue to bring it up and continue to want to discuss it. We understand that it's easy for you guys to look at Representative Spencer's bill and think that, look, if somebody wants to go up in a rocket, then I'm just fine with them signing a waiver to agree not to sue the party that put them up there. And in all candor, I think we understand that could be a way you look at the statute. Keeping in mind that the license that Camden County has applied for doesn't apply is currently for a class of rocket that it's not envisioned would be used for space tourism. I mean, it's a medium lift class rocket which is used to put payloads into orbit. So this statute, as it currently exists, really has no relevance to the proposed development in Camden County. This statute is really more about sending a signal to the space industry that Georgia wants to be in the launch business. We would urge this committee that this situation is not, there's enough uncertainty around this project. The EIS is not back, the environmental impact statement. The FAA hasn't finished its analysis as to whether it's safe to launch these rockets over the Cumberland Island National Seashore. The Department of Interior, the U.S. Park Service, has issued a very strongly worded letter basically saying that they felt like any closure of the park would amount to an unlawful taking under a federal statute, transportation statute. There's just a lot of uncertainty surrounding this project right now. And it seems premature to us for the Georgia legislature to pass a law that is meant to grease the skids for the project at a time when none of us know enough about whether the project is in fact viable. Saying all that, if it's the will of this committee to move this statute forward to the Rules Committee, we do have 3 amendments that we have circulated. I believe you have copies of them. If you don't, I have copies I can pass out. Proposed amendments to the bill. And Chairman, if I could quickly just go through each of these 3, and I can tell you the rationale for what we're proposing. The first amendment follows the comment that Representative Ms. Evans offered earlier. Our proposed amendment would delete lines 64 and 65 of the bill, and the rationale for that being this statute was originally designed to dovetail with the federal statute that provides for waivers for spaceflight participants. The federal waiver doesn't apply to downstream manufacturers. So the federal statute does protect the company that puts the person up in the rocket and their subcontractors, but it does not protect for instance, the person who makes the spacecraft or the components of the spacecraft. This is a pretty significant departure from Georgia's current tort law with respect, which implies a duty on all manufacturers to manufacture products free from defects in either materials or workmanship or design. So it's in the middle of the bill. It's easy to overlook, but this would be a pretty dramatic departure from Georgia's current tort law. Our proposed amendment would delete line 64 and 65 and would not give those suppliers the same protections that the company that actually sells the ticket has from liability under this statute. So in other words, a family that had someone that lost their life, they could still, if it was proximately caused by the spacecraft itself being defectively manufactured, designed, or built, that family would still have a cause of action against the company who made the spacecraft vehicle. The second amendment we proposed is a carve-out that follows, as Representative Spencer pointed out, the statute does not apply to injuries that are approximately caused by gross negligence or intentional acts. We would add a third to that. We're proposing to add a third to that, which would say that this statute would not provide immunity for injuries that are approximately caused by the spaceflight entity's failure to comply with all regulations, rules, and directives established by the Federal Aviation Administration applicable to spaceflight activities. So in other words, if you don't follow the FAA's requirements, you don't get the benefit of the liability immunity.
Ask a question
Yes,
before
sir.
we go any further. Did you bring these before the subcommittee for consideration?
Yes, sir. Chairman, we did. Yes, sir.
And what happened at the subcommittee?
They were debated and voted down
All right.
in the subcommittee. Yes, sir.
Thank you.
The third is the bill should contain a sunset provision. The federal statute that this statute dovetails with only with respect to spaceflight participants, not with respect to subcontractors, but the Congress inserted a sunset date of September 30th, 2025 with respect to the provisions that dealt with spaceflight participants. And the rationale behind that was that at some point the thought was this industry should be able to stand on its own 2 feet and be subject to claims. In other words, it should be safe enough at that point that the industry no longer deserves a blanket immunity from a explosion or from a hazard. This statute, the Congress had a lot of input from the FAA and NASA in crafting the federal statute. We feel like the state statute is the exact same subject matter, and we're dealing with the exact same issue. It's the waiver of liability for a spaceflight participant. In fact, this statute is meant to dovetail with the federal statute. We feel like there's good rationale for a sunset provision in the state statute as well, and we're proposing the sunset date be the exact same date that's in the federal statute. So those amendments are for the committee's consideration, and yes, Chairman, to answer your question, we did bring these up in subcommittee, and they were not approved.
Thank you, Mr. Lang. Any questions of the presenters? We do have, yes, sir.
What's the minimum amount of time that a launch can be scheduled, a commercial launch?
When you say minimum amount of time,
Like how far out do these things need to be scheduled if they're going to try to do a launch here?
it varies pretty dramatically, and a lot of times they get scrubbed. So the first date is the anticipated launch date, and that was an issue that was raised particularly by the National Park Service, is because a lot of times what happens is it's very weather dependent. For instance, so if the weather changes, if winds shift, a launch will get scrubbed, or if there's any sort of mechanical issue. So sometimes a launch is scheduled for a particular date won't occur for 5, 6, 7 days later, sometimes more.
And I've camped on Cumberland Island. You generally have to reserve that about 6 months out,
Yes,
right?
and that's actually the exact comment that the Park Service had, was with respect to our visitors, we would, if this spaceport happened, we'd have no ability to operate our park as we currently operate it, because people do make those reservations for months and months in advance, and they would be operating their park around the launch schedule of a commercial space company. So,
Thank you. Anything further? Yes, sir. Mr. Fleming?
Who runs the park?
the National Park Service.
Federal government.
U.S. government, yes, sir.
Same people that have to give a permit to allow this to go forward, right?
Different department, but same government, yes, sir.
Thank you.
Okay. Nothing further. Thank you for
Thank
your
you.
presentation.
Thank you.
I believe Mr. Jones, Representative Jones is.
I moved on you, Mr. Chairman.
Here we are. Moved. Yeah, I thought you were on one side. I think you wanted to speak to the committee on this proposal.
Thank you, Mr. Chairman and committee members. I'll be brief. I want to speak in very strong support of this measure. The economic benefit to Southeast Georgia and indeed the entire state of Georgia will be tremendous. These jobs typically pay $80,000 to $90,000 per year, and these are exactly the kinds of jobs that we need to encourage be developed within the state of Georgia. One other side benefit of a launch pad in Southeast Georgia is there will be a benefit in encouraging our students, high school students, to be more involved in STEM and STEAM education. It's been shown that when these kinds of activities occur in an area, that kids become more excited and interested in the science, technology, the whole STEM realm of education. So it's has many, many benefits even into our educational system. So I would like to strongly urge the committee to not water down this legislation, but let it proceed as submitted. Again, just huge, huge benefits to the state of Georgia.
Thank you, sir.
Thank you.
Anyone else wish to speak to the committee? Yes, sir. If you want to come forward and have a seat and give us your name and who you represent, if anyone.
Mr. Chairman, my name is John Simpson, and I'm here on behalf of Camden County. I just want to address some of the issues that were discussed earlier.
What's your position with the county, may I ask?
I'm a consultant for the county.
Okay.
Just wanted to see, or just wanted to discuss some of the issues that were discussed by the property owners, and to correct some issues that were brought before the committee. One of the claims that was made was that any space flight would require the closure of Cumberland Island, and therefore would be a taking of property rights. That's actually a misreading of the federal law. A closure area is only required for non-authorized persons. Homeowners are considered to be authorized persons, so therefore that would not be an issue, would not necessarily be a taking. That notwithstanding, this is not an issue in the bill. The bill is related to space flight participants. It's not a property rights bill. It has nothing to do with property rights. But I wanted to make sure we cleared that up. Secondly, the bill is not just limited to Camden County. It would apply to any spaceport that were to operate in the state of Georgia. So if there are anybody that wants to do horizontal launches, which is where you take an airplane, launch a rocket off the bottom of an airplane, that would, anybody that wanted to be a space flight participant in one of those areas would be able to do that as well. So we shouldn't attack the legislation because of particular concerns that folks are raising in Camden County, because it would apply for all of the state of Georgia. It's not a specific piece of legislation for Camden County. Finally, I'm sorry, and the last thing I wanted to talk about was the class of rockets. Medium lift vehicles are actually used to put people into orbit. They're of course used to put satellites into orbit as well. Both United Launch Alliance and SpaceX are considering using their current fleet of vehicles, which are medium lift vehicles, to put people into orbit. So,
thank you, sir. Any comments questions rather from members of the committee? One question I've got, I guess I'm just not educated enough, haven't been involved with this, but I see on the plat or this map, this yellow area. Is that a fixed and like chisel and stone, or is it something that varies depending on what weather may be or other circumstances, or what?
it actually varies on what sort of payload you're trying to put into orbit. That is a launch trajectory. If you're going to the International Space Station, for example, you may be going significantly farther north. If you are trying to get into geostationary orbit, you may be going in a completely different trajectory. That is just one sample trajectory. It's not based on anyone that's actually filed anything with the FAA. It's just something that has been drawn.
Area. Okay. Is there a set in legislation, federal law, rules, regulations as to what the size of this area is to encompass width-wise? I know this width looks like, I'd say, just from gazing at it, maybe about, 75 miles or 50 miles?
The space around the launch site is codified at 10,900 feet. so roughly 2 miles.
Codified 10,900 feet, what, wide?
It is a diameter.
Diameter, okay.
So I'm sorry, a radius of 10,000.
So see that circle, is that what they were talking about there?
Exactly.
The yellow area.
I'm sorry?
What about the yellow area fanning out from there?
I'm not entirely certain on the what the specific trajectory and exclusion area would look like per launch, and that's because the FAA licenses each launch individually. So once you have, what we're applying for is a launch operator's license that gives you the permission to do the site, and then every individual launch after that would have to be licensed separately.
So if you launch, doesn't mean necessarily that yellow fanning out area is the size of what's needed.
That's an estimation. It's not necessarily what would be required. The FAA will determine that on each individual launch.
Thank you. Anything further from any member of the committee? Appreciate your coming to us and speaking about it. Anyone else wish to address the committee? If not, the chair will close all further comment. The bill is now in the breast of the committee. Do we have a motion? Motions do pass with second. Do we have discussions? First of all, anyone will have a discussion about the bill? Do you have any proposed amendments, discussion? Mr. Fleming?
Mr. Chairman, Representative Evans, you've talked about some of the amendments that have been offered to us in writing. And Amendment 1 is the one that you talked about the most, that would change subsection B to a supply of services related to space flight activities. If this committee were to support that amendment that you proposed, could you support the bill going forward?
The amendment I was going to propose relates to adding that Federal Aviation Administration language. I think that's the better route since it's tested in other states and it gets to the point of making sure that these components are safe. I would hope that I could get support for the amendment so that we can place some priority on our citizens and not just potential economic development. I know it's always a balance for us, but on this one, I think we need to be safe. As far as my support of the bill, my no vote on the bill has more to do with the signals that we're sending. I mean, I understand we want to send a signal that we're open for business, but we're also, by this, sending a signal to business about how we're going to limit their liability before we even really know all the risks that are involved here because we're waiting for the study to come back. And secondly, we're sending a terrible message to our current residents on Cumberland Island that their concerns are not of concerns to us. So my opposition to the bill is very different than trying to perfect the language to make sure that if this passes that we are at least protecting our citizens from safety hazards that we know exist.
So the short answer is no. If we
is
agree
no.
to your amendment, you would not support the bill going forward. Okay.
Yes.
All right. Did you have further discussion, Ms. Evans? Do you want to offer amendment?
Just amendments at the appropriate
All right.
time.
Is there any further discussion regarding the bill by members of the committee? If not, the chair will open for amendments. Ms. Evans?
Thank you, Mr. Chairman. I would propose an amendment on line 65 at the end of the current line, inserting before the semicolon the following language: that have been reviewed by the United States Federal Aviation Administration as part of issuing the license.
So it's reviewed by the United States Space Administration as part of issuance of a license?
That have been reviewed by the United States Federal Aviation Administration as part of issuing the license. And that language mirrors Florida and Texas.
All right. Does everyone understand the amendment? Any discussion regarding Evans' amendment? I think we had Mr. Driver, your button pushed? Okay. That's all right. We had a second by Ms. Oliver, correct? Do you have a discussion, Ms. Oliver?
I'm respectful of the argument that is frequently made. If you're going to be against the bill, why are we going to address your amendment? And I don't think that's, I think that's a very valid point, but it's also valid that a piece of legislation moving forward, we have an obligation to improve it to the interest we're working towards. And I don't think it's totally determinative of how people respond to an amendment from someone who is going to be voting no on the bill anyway. I wanted to make, because that's a tactic that's appropriate to use in many different contexts.
Mr. Fleming.
I don't agree with the amendment. I was just trying to work together, compromise. So, thank you, though.
All right. Any further discussion on the Evans Amendment? If not, we'll have a vote on the Evans Amendment. All in favor of the Evans Amendment signify by saying aye. Aye. Opposed, like sign.
No.
The chair is in doubt. We'll have a show of hands. All those in favor of the amendment, please raise your right hand. I count 5 hands. All opposed to the amendment, please raise your right hand. Motion fails. Are there any other amendments to the bill? If not, Ms. Evans?
Thank you, Mr. Chairman. My last amendment would be to add a section 4 that adds a sunset, and the language would be that this act shall cease to be effective on September 30th, 2025. And as was presented in testimony, this mirrors the federal legislation, and if it's deemed by 2025 that we still think the industry needs extra protection, of course, we could extend the sunset.
All right. Got a motion and second to Evans Amendment number 2. Any discussion on the amendment? There being no discussion, the chair will call the main question, which is amendment number 2. A vote in favor of the amendment will be shown by raising your right hand. All those in favor, please raise your right hand. 3, 4. I count 5. All those opposed to the amendment, please raise your right hand. Motion fails. Are there any further amendments to House Bill 1? If not, the chair will call the main question, which is approval of House Bill 1, which is LC 363182. This is bill as presented to committee. All those in favor of the bill signify by saying aye. Aye. Opposed, like sign. Chair rules the motion carries. House Bill 1 is approved for sending to Rules Committee. That is a committee substitute? It is, sorry. It is a committee substitute. I missed it. Thank you. Just a second. Get my paperwork. Got to give them a chance to get out. You want to present your bill? Yes, sir. Got a Jones bill. Let's see, Jones. Mr. Jones, you want to present your bill? Sure. Come on up. I'll let you do that since we'll get you out of here. Let me do this next. A quick bill. We have next before the committee House Bill 14. And Mr. Jones, we're pleased to have you with us.
Thank you, Mr. Chairman and committee members. To start, this bill was passed out of committee last year, and we ran out of calendar time on the Senate side, so we're bringing it back. This bill is intended to codify into law existing current practice among our county sheriffs. That practice is, first of all, let me mention, the vast majority of sheriffs in the state of Georgia are paid on a salary basis. But
they all are.
In fact, they all are.
Yeah.
Okay. I do, if there were any that weren't, it was okay, no more fees. So this language just puts and codifies into law that our sheriffs who are paid on salary, should there be any fees collected within their counties, that those fees be remitted within 30 days to the treasurer or fiscal officer of the county. That is the extent of the bill.
Has this come about, just as a curiosity, as a result of a misunderstanding or a failure on part of one of the sheriffs to properly submit their funds?
No, sir. Back in 2011, there was a jury selection bill that was passed through and passed, and this language previously existed in code, and was inadvertently omitted. But the sheriff's associations, ACCG, and others just feel like we'd be better off having this statement codified into law just to make it clear that sheriffs on salary must remit fees to the county treasurer.
All right, thank you. Any questions? Mr. Fleming, good. Blinking, please.
Thank you, Mr. Chairman. And once again, this is a last year bill, so I'm trying to think back on it. As I recall, you worked with law enforcement involved on this, and they were okay with this.
Absolutely.
Is that right? They're
The Sheriff's
supportive of it?
Association, ACCG, yes, absolutely, 100% support.
Thank
And I
you.
think that was verified again. I verified that again a couple days ago, but I knew that that was the case. Yes.
Thank you, sir.
All right. Anything further from any member of the committee to the presenter? If not, is there anyone else who wishes to speak on House Bill 14? ACCG present, and you're in favor. All right, we got a favorable support by ACCG. Anyone else wish to speak to committee? If not, the chair will close off further public comment. House Bill 14 is now in the rest committee. The chair will entertain motion. Motion is due pass with a second. Any further discussion? Are there any amendments? If not, the chair will call the main question, which is a due pass to House Bill 14 as presented to committee, LC 297180. All in favor signify by saying aye. Opposed, like sign. Motion carries. Thank you, sir.
Thank you,
Glad to
Mr.
have
Chairman.
you with us.
Thank you for your time, committee.
Yes, sir. Mr. Fleming, I think you've got one on here. If you'd like to bring up House Bill 88, please do. I'll turn on your mic for you. Thank you.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, House Bill 88 arose from a situation in my judicial district in Augusta whereby we realized we probably needed to make a little change in our election laws as it relates to our Superior Court judges. The Georgia Code and Constitution has certain requirements for members of the bar to run for Superior Court. In Augusta, we had a situation where someone challenged one of our incumbent judges. When the person qualified to run, they were up for disbarment. After the election, they were disbarred. But if you read the current code in Georgia, it is not clear, although the current code talks about having to be reinstated if you've ever had been disbarred, it's not clear that if you were disbarred after you qualified, whether or not you could take office or serve as a judge. So what this bill does is it simply clarifies that if you are disbarred, you are no longer qualified to be a judge, Superior Court. So we had Jeff Lanier originally dealing with elections and Ledge Council drew this bill up. Julius Talbert, our council here, made one small addition to it to perfect it better, and we added that in subcommittee, simply making it clear, as our Constitution states, that it would take an order from the Supreme Court to remove this person. So that's the attempt of the bill that you have before you, Mr. Chairman. Our Constitution gives us the authority to do this. Obviously, in Article 6, Section 7, Paragraph 2, it says there that there are certain qualifications to be elected Superior Court judge, and subsection E says the General Assembly may provide by law for additional qualifications, including but not limited to minimum residency requirements. So what we're doing here is simply fulfilling an authority we have under the Constitution to require additional requirements, and that would be that you need to remain a member of bar and not be disbarred. In closing, I guess I would sum it up by saying that we obviously know that if you are a judge and you do something you shouldn't do, you can be brought up for disbarment before the Supreme Court by the JQC. We as attorneys, if we do something inappropriate, we can be brought up through a process for disbarment through the bar, ultimately decided by the Supreme Court. But there's that no man's land in between. If it happens when you're an attorney, but you get disbarred when you're a judge, and that fills this gap there. Judge Tom Campbell was here when we discussed in the subcommittee, and he came and testified on behalf that he had looked over it himself and he thought it met the needs that we were trying to fix. So I would be happy to try to answer any questions beyond that, Mr. Chairman, if I may.
Thank you. Does any member of the committee have questions of the presenter? If not, we appreciate your comments. Is there anyone else in the audience who'd like to address the committee on House Bill 88? If not, we will close all further public input and comments. The bill is now in the breast of committee. The chair will entertain motion on LC 410946S, House Bill 88.
Do pass.
Motion is due pass. Do we have a second? Second. It's been seconded. Any discussion on the motion? Are there any amendments? This is a substitute House Bill 88. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you.
Thank you, Mr. Chairman.
Now, at this time, turn over to you, Mr. Fleming, as Vice Chair. To chair the committee, I have a bill that I would like to present to the committee.
You want to go with 75 there, Mr. Chairman,
Yes,
the last one on our
Yes,
list?
sir. Yes, sir.
At this time, the committee will entertain House Bill 75. Mr. Chairman, you want to tell us about House Bill 75?
Thank you, Mr. Chairman. May remain in my
Absolutely.
seat on it.
Absolutely.
The background of this, the bill was brought to my attention through Department of Family and Children's Services, and let me state to the committee and the outset, I'm quite zealous in being sure that we protect the right of transparency and open records with government. There are those circumstances that arise, however, where there is a need for various reasons to have, for a time, a protection of certain information and records, and I think this is one of them. We have some individuals with the Department of Family and Children's Services. I'd ask if you would, while I'm sitting here, if you would come up to the chairs here, please, and let me get you to assist me in this, but I'll give you some background. There was a case, as I understand, that developed in North Georgia, where there was investigation ongoing regarding the death of a child, and the law enforcement and district attorney's office, I believe up there, felt a need to inform the Department of Family and Children's Services of information that they had regarding the circumstances of this child dying, because there were other children, I believe, in potential danger. And so the information was shared while there was still an ongoing investigation into this child's death and the circumstances of it. The parties who represented the individual who was being alleged party of the death of this child, were able to obtain what would be otherwise confidential information that would have been within the law enforcement agency, but for reason of the desire to protect the child, had been shared with the Department of Family and Children's Services in order that the department could make an informed decision about steps to be taken to protect the other children. And the information was not, of course, protected at that point, because it had now left the hands of law enforcement alone and had gone into another party's hands. So that was to the detriment of what the law enforcement needed to be done, because now there was already the dissemination of this information obtained by the alleged perpetrator of the criminal act. So the point being with this, we felt there is a need to allow law enforcement in limited circumstances to share this information with Department of Family and Children's Services when it is deemed necessary that there be protection of that information for the purpose of either child abuse, neglect, and dependency. So this is the reason why the bill is before you. If you would, we have two representatives of the Department of Family and Children's Services. If you pull the mics around and introduce yourselves and give your thoughts and comments on the bill.
Yes, sir. Thank you, Mr. Chairman and members of the committee. My name is Ashley Fielding Cooper. I am the Director of Legislative Affairs for the Department of Human Services, which includes the Division of Family and Children's Services. First, I would like to apologize on behalf of Director Cagle. He very much wanted to be here today to discuss the need for this bill with you, but he had a previous engagement. If you will, Mr. Chairman,
Sure.
I do have a letter from Director Cagle that he would like to
pass
share with
that
the
out,
committee.
you're welcome to. We'll give it to one of the aides here and let him handle that for you.
I'll let Ms. Egan introduce herself.
I'm Vivian Egan, and I'm General Counsel for DFACS.
Glad to have you with us, Ms. Egan. We've met previously, and I appreciate your work. Is what you want to add to the bill, from my prior comments?
I believe you hit the nail on the head, Mr. Chairman. The way that this is drafted, it's narrowly tailored so that the public can still access DFACS records in the event of a child death or serious injury to hold the department accountable for its actions in protecting children. However, it closes a loophole in current law, which allows the public to access information that would otherwise be confidential if it was on a different letterhead. For example, if it was on, if it had Catoosa County Sheriff's Office letterhead or a district attorney's letterhead, it would be confidential in this case, but because our case manager has written it down third hand in our case file, it is subject to open records.
All right. Any questions of the representative of the department or of myself? I see none. I think you're good.
All right.
I took over.
You're doing a great job. I got the sense you've done this before.
Got carried away here.
Absolutely. Okay, so is there any questions from the committee for our two witnesses that are here with us today? Okay, thank you all for being here. Hang on just a second. Let's see, is there anybody else here signed up, Jordan, on this bill? Do we have anybody signed up? Okay, anyone else wishing to testify on this bill? If there is none, then thank you all very much for coming today. We appreciate that. We'll bring the bill back to the committee. Is there any further discussion before I ask for a motion? If there is none, is there a motion on House Bill 75? There's a motion. Is there a second?
Second. Yeah.
Any discussion on that motion?
Let me just close out in saying that I met with the First Amendment Foundation last week and brought this bill to their attention because I knew it was something that they would probably have interest in due to the fact that we're looking at narrowing down some potential opportunity to get public records, and I did not receive any opposition from them on this point.
Okay. Any further discussion regarding House Bill 75? We have a motion to pass. The chair will call the main question. All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? There are none. The bill passes, and we'll move to rules.
All right, thank you, sir. And with that, we will, I think, have completed the agenda for today. I appreciate your attendance. Is there anything else to come before the committee? If not, we will stand adjourned until Thursday. Thank you.